Between 1992 and October 2013, we enjoyed a situation where there was strict liability for defective work equipment under the Provision and Use of Work Equipment Regulations 1992 and then 1998. This covered that most vexed of situation where the defect within work equipment is latent rather than patent, or hidden and cannot be discovered by close examination. Clearly, in our post-Enterprise Act world, we can no longer, as of right, rely upon the Provision and Use of Work Equipment Regulations. It is a moot point what role they play post-October 2013, but it is not in any sense moot that strict liability for defective equipment no longer exists. It is helpful to look at a piece of legislation which still exists but really has not been of much interest to anyone post 1992 and pre-2013. The Employers' Liability Defective Equipment Act of 1969 was an attempt by an earlier generation to deal with that vexed issue of the latent defect. It does not create a new tort. It certainly does not create strict liability, but what it does is it deems an employer liable to an employee for acts and omissions, breaches of duty by a manufacturer or supplier in relation to work equipment provided by the employer to the employee. The third party doesn't have to be identified. The transaction between the third party and the employer doesn't have to be a transaction of sale. It could be hire or lease or anything of that sort. But it is necessary to establish fault by the third party. Now, in order to understand the Act, it's probably helpful to look at the problem that the Act addressed. And we really have to go back to the 1950s for that. A case called Davey and New Merton Board Mills Limited, which culminated in 1959 in the House of Lords. Now, Mr. Davey obviously was an employee of New Merton Board Mills Limited, and they provided him with some sort of cold chisel or drift or similar sort of equipment. It had been purchased from a reputable retailer and manufactured by a reputable manufacturer, and it looked okay. But it wasn't. It was a defective. There was some sort of defect in the manufacturing process, perhaps the hardening process, and as Mr. Davey used it, a piece of metal detached from it and entered his eye. He sued his employers on the basis that they had a non-delegable duty, and of course the relationship between employer and employee gives rise to non-delegable duty, to provide him with decent, safe work equipment. They defended on the basis that the only duty they had was to purchase the item from a reputable source, and obviously if it was visibly defective, to take it out of use. Well, as I say, it went all the way up to the House of Lords, and the House of Lords agreed with the employer. This gave rise to a decade of debate and consideration, and the Employers' Liability Defective Equipment Act 1969 arose from it. And effectively it meant in those circumstances Mr. Davey could sue his employers and they could not hide behind the fact that they had done nothing wrong, because they hadn't, had they? Well, the Act is quite broadly defined, and it says that where an employee suffers injury in the course of his employment in consequence of a defect in equipment provided by his employers for the purposes of the employer's business, and the defect is attributable wholly or partly to the fault of a third party, the injury shall be deemed to be attributable to the negligence on behalf of the employer. Business includes public business and government and local authority. Employee is pretty widely defined. Equipment includes any plant and machinery, vehicle, aircraft and clothing. And personal injury includes death, both physical injury and psychological injury. So it is quite widely defined. And in the period when the Act was regularly in use, it was defined even more widely by the courts. There was a case called Coltman and Bibby Tankers in 1988, which found that the whole of a ship, not merely the component parts of it, was work equipment for the purposes of the Act when the ship unfortunately sank with all hands on board. Again, in a case that was close to hearts of Liverpool practitioners, Knowles and the Liverpool City Council in 1993 similarly went to the House of Lords when they decided that a flagstone, which was apparently a green flagstone, not properly cured by the manufacturers, and which shattered when it was being used by Mr. Knowles and injured him, was in fact work equipment. Difficult to know what the Liverpool City Council thought it was, but they took it to the Lords in order to establish that. So there we are. The Act is very much part and parcel of our armoury going forwards as claimant practitioners. It is worth remembering, it is worth thinking through. It will not apply to every situation of latent defect, but looked at imaginatively, it may well apply to quite a few. I see no reason why that sort of quasi-strict liability created by the Consumer Protection Act of 1987 in relation to defective designs and defective manufacture of equipment could not apply to the Act, because obviously the Consumer Protection Act was not in place when the Employers' Liability Defective Equipment Act 1969 was passed, but fault means negligence, breach of duty, other act or omission which gives rise to liability in tort in England and Wales. The Consumer Protection Act covers not only domestic use, but items supplied for use within a place of work. I'm not aware of any authority on the point, but as I say, it seems to me to be eminently arguable. Well, I hope that's been useful, because we really do need to remember that the Act still exists and cite it when appropriate. We need to remember that it is a deeming act and what that means. Thank you very much for listening this morning.